Hello everyone. Thanks to you all for attending our talk today on white hat privilege. My name's Jake Osborn. I'm with the law firm Goodwin LLP, and for the past 8 years or so I've been representing tech companies, hackers, and companies in the cybersecurity space along the way. I'm incredibly fortunate to be joined today with my co-presenter, Karen Neuman. She's a partner who leads the privacy and cybersecurity practice in Goodwin's DC office. She joined Goodwin about a year ago after her role as Chief Privacy Officer of the Department of Homeland Security. She's a top expert in her field, which focuses on data privacy and cybersecurity issues, and we're lucky to have her for today's talk. Before that, before being with DHS, she co-founded a law firm where she advised clients on privacy issues.
Thanks for that introduction, Jake. I feel like we're hopefully in the same time zone as the people in the back of the room. It's been great working with you two this past year, and I'm looking forward to more of the same. For those of you who don't know Jake, he's a computer programmer turned lawyer. And he has degrees in math and computer science, and he was actually a software developer before becoming a lawyer. So his insights on the issues we're going to talk about today, privacy and cybersecurity, are incredibly helpful. But I'm told we only have 50 minutes, so let's dive right in. First, some legal stuff. The opinions we provide today are our own and don't constitute any positions of Goodwin, the Black Hat organization, or the US government. Our opinions also are not legal advice, and anyone seeking such advice should consult with their own lawyer.
Thanks, Karen. So what do we mean when we talk about white hat privilege? Well, the answer takes just a little bit of an explanation. And while we would like to take the credit for coming up with this concept, the ideas behind this talk actually originate with a client of ours. So for the past few years, we've represented Offensive Security, the team that's behind Kali Linux, the team that provides various certifications for testing, the team that maintains the exploit database, and many of these questions and issues that we're going to address today have surfaced during the course of that representation. So last year, I actually came out to Black Hat, and I came out a little bit early to attend some training with Kali Linux. And I was surprised by how many legal questions came up from the Black Hat community in general. So Offensive Security said to us, well, gosh, it'd be really great if you could come back next year and do a talk at Black Hat that would be practical guidance for cybersecurity professionals. And so they really asked us, what tools do we have at our disposal as cybersecurity professionals to protect our customer data within the law? And so considering that question, we coined the phrase white hat privilege. And what we're describing with that term is all of the tools, which are either legal tools or technical tools, that security experts can use to protect customer data, as well as tools that a security professional can use to protect his or herself.
But first, it's important to understand who might want to get hold of your customer's data to determine what different legal and technical tools that might be available to protect the data and yourself. The first group, the public, might include third parties, competitors, vendors, and the like. The second group are bad actors. Bad actors often seek access to confidential information, to monetize the data, gain notoriety, embarrass a company, or steal corporate IP, or for other nefarious purposes. The third group, the government, includes nation states, regulatory authorities, law enforcement, and border agents. Now, this isn't an exhaustive list of the groups that you should be aware of, but I think I've hit the essential food groups. We know that bad actors, for example, will commit unlawful acts to try to gain access to your customer's data. And this is where certain tools like a legal privilege, for example, or contract terms are useless. If bad actors are willing to break the law to try to gain access to your customer's sensitive data, they won't care what your contracts say. The government may seek access to your customers' information through various other means, including a regulatory filing, a subpoena demand in a civil or criminal case, a request for technical assistance like we saw during the FBI Apple dust-up, or a search for your laptop at the airport. Again, because the groups that may want your customers' sensitive data are distinct, it's very important to appreciate the variety of tools that can be used to try to protect against exposure and access in each situation. Now, as Jake indicated, the name of this talk is white hat privilege. And apart from trying to be clever, we use this term to describe tools, a holistic set of tools that can be used to protect your customer data. But this term shouldn't be confused with a legal privilege. The phrase simply borrows from the concept. Now, when I say legal privilege in the context of this talk, I'm referring to a tool that can be used to protect sensitive communications and information in the lawyer-client relationship, from disclosure to the public, third parties, or the government. The privilege belongs to the client, not to the lawyer. And the idea is that a lawyer can best prepare for and argue a case or otherwise represent their client zealously and effectively if and only if the client is free to disclose everything, the good, the bad, and the ugly, to the lawyer. For the attorney-client privilege to apply, the communications must have been made to the lawyer for the purpose of obtaining legal advice. When a communication is under this cone of silence, it is generally protected, meaning that it is free from a forced disclosure to anyone, including the government. Now, lawyers also have a duty to keep confidential anything they learn about the client, regardless of whether that information came directly from the client or from another source. There's some exceptions to these rules. For example, if the client waives the privilege and shares information with a third party, then the information might lose protection under the attorney-client privilege. But the practical outcome is that, as lawyers, our clients can generally share sensitive information with us, knowing that it remains protected. Now, you may be wondering if the law recognizes a security consultant privilege. Nope. Sorry, I wish I could say otherwise. And this is a real dilemma for security consultants because you are regularly entrusted with your client's most sensitive data, most sensitive dark secrets, even information that could take down a company. You're asked to infiltrate networks, find flaws, gather sensitive data, document exactly how to do it, all the while knowing that your findings could be used to the worst detriment of your customers. If one of the groups I mentioned at the start of this talk were to gain access to your customer information, not only could your customer be harmed, but you could be harmed as well. You could be in breach of contract for having disclosed your customer's confidential information. But there are ways to bring your activities under the umbrella of the attorney-client privilege, and that involves being retained by your customer's lawyer to perform your services and being able to rely on another important privilege, the attorney work product privilege. And a recent California case illustrates this privilege. In that case, the credit reporting agency Experian announced that it had suffered a data breach, and a class action was filed against the company the very next day. When Experian discovered the breach, it immediately hired outside counsel, who in turn engaged the forensics firm Mandiant to investigate the breach. The plaintiff's lawyers demanded a copy of the Mandiant report, presumably hoping to find bad facts that it could use against Experian. And Experian's lawyers refused to provide the report, so the plaintiffs asked the court to compel production. The court ultimately held that the report was protected from discovery by the attorney work product doctrine. In part, this decision was because Mandiant had delivered the report to outside counsel only, who shared the report exclusively with Experian's in-house lawyers. The full report was not shared with Experian's incident response team, and this appeared to be an important factor in the court's decision to protect the report from disclosure. Essentially, because Experian's outside lawyers had instructed Mandiant to perform the forensics investigation, and because Mandiant worked with the lawyers directly, these communications were all protected as work product done in anticipation of litigation. Other courts have made similar findings. So, what's the takeaway? Well, while you may not enjoy legal privilege rights for your communications directly with your customers, you or your customer may be able to make use of a legal privilege in circumstances where there's a legal demand for your customer's information. Now, in practice, this might come up in two different contexts. First, it can apply to your own communications with your lawyers. In that case, the attorney-client privilege belongs to you as the client. Second, as we saw in the Experian case, your cyber and forensics work might be able to piggyback onto your customer's privilege to the extent your work is done as part of the work product in anticipation of litigation. Recognizing this, you should take steps to be careful to get a lawyer involved early in those situations so that steps can be taken to ensure that your customer's information is protected from legal demand.
Thanks, Karen. Now we're going to move on to another tool that a cybersecurity professional can use to protect sensitive client data, and that's your contract with your customer. Recall that we had identified the various groups at the beginning of this talk that you're going to protect your client's data against. We had the public, we had bad actors, and we had the government. Well, your contract is really only useful for protecting the customer's information from the public, although it can also be used as a very good tool to protect your own rights. Because of the nature of your work, you absolutely need an A+ contractual agreement with your customer. And this is always a bit of a balancing act. On the one hand, you don't want to propose some 50-page document that's going to be very costly and burdensome to negotiate. But on the other hand, you need to cover the most common issues to protect yourself. So now we're going to talk about what some of those common issues are that arise during contract negotiations for security consulting work, and what we think are some of the best practices for security professionals. The first item we have here is the DTR talk. This is just defining the relationship. It's the who, what, when, where, and how of the engagement. A security consulting agreement should accurately describe who is performing the services. Consider which corporate entity is listed on the contract. If you're affiliated with multiple corporate entities, we usually recommend incorporating some level of flexibility into the contract. Ensure that any affiliates of your business may be utilized to the extent you typically utilize those resources. And also clarify whether any subcontractors or other non-employee personnel may be used at your discretion. Now, this may seem like an obvious point, but your agreement should also clarify what the engagement will entail. Will it be limited to scanning, or will it also include penetration testing and delivery of exploits? Will it involve tailored or customized attacks? Will it involve the development of 0 days? The key here is to make sure that you have consent in written form from your customer for all of the different anticipated activities. This is very crucial to protecting you and ensuring that you do not violate certain hacking and other computer type laws and statutes, such as the Computer Fraud and Abuse Act, or any other regulation that requires consent of the parties for certain activities. So which technical tools will you use in the engagement? We generally prefer to leave this to the discretion of the consultant, but you want to make sure that the contract accurately reflects that. When is the time frame for the activities? Are the services ongoing? Are they limited to just a few months? Where will the services be performed? Are they remote? Are they on site? Do they include an attempt to physically breach the location? And finally, what's the customer's expectation for the end product? Will the engagement result in a white paper, a final report? And what will be included in that report? These are all questions that you should address in your contract. Oh yeah, and you might want to put how much money too. That's usually a pretty important thing to put in the contract. Another important clause in the contract is the confidentiality clause. So this clause addresses confidentiality obligations that are very akin to the lawyer's duty of confidentiality to their client, but this time it's bound in contract law and not in legal ethics rules and obligations. So a good confidentiality clause will often go both ways. You'll promise not to disclose your customer's confidential information, and your customer will promise not to disclose your confidential information. Sometimes we see these obligations set forth in a separate agreement called a non-disclosure agreement or an NDA, rather than being embedded directly into a consulting agreement, while sometimes we see these issues directly addressed in the consulting agreement. Really, either approach will work as long as if you're using a separate NDA, you make sure to harmonize the language with your consulting agreement. Make sure there are no terms that are conflicting. And there are many questions that you should address in formulating a strong confidentiality clause. One example is that we often see is whether you can share exploits and vulnerabilities that you discover with third parties. So for instance, what about notification to a third party when a vulnerability is discovered in third-party software? What's the process that the parties are going to go through when that happens? Who has control of that process? Are you, as the consultant, able to use the name of your customer to promote your work for future engagements? Or, on the other hand, is the entire existence of your engagement confidential? One recommendation we typically make to our clients is that the security professional should reserve the express right to comply with any legal law enforcement demands or requests. And we'll talk a little bit more about this later. But we do think that's an important protection for you as a security consultant because it makes sure that you're not put in a difficult position later of breaching the contract in order to comply with lawful demands for information. Now, these are all issues that are typically negotiated at the business level and then accurately reflected in the legal documents that describe the engagement. Another crucial element of any consulting contract is a limitation on your liability for the work that you're doing. You're being engaged to hack, so what could possibly go wrong? Well, the answer is pretty much everything. When you engage in this risky type of work, you run a real risk of taking down your customer's entire network or otherwise causing serious damage or data loss. Now, I know you all are going to do your best to make sure that dramatic outages and data loss will not occur, but it's still a very tangible risk. And you should think about it this way. Does it make any sense for you to be at risk for owing your customer millions of dollars for their loss of data or for their downtime when, let's say, you're working on an engagement that's a $50,000 engagement? No, it doesn't make any sense to put yourself at that risk. And in many ways, your customer should appreciate that when they hire you. You're going to do your best to make sure these terrible things don't happen, but by the very nature of your work, it's a risky endeavor. So one suggestion we have is to revisit your own professional liability insurance. Understand exactly which losses are covered and which losses are not covered. You should be aware that one common exclusion in these insurance policies is for any liability arising out of any data loss or any damage to data. And what that would essentially mean is that you're going to be on your own and unable to make an insurance claim in this worst case scenario. So what does a fair liability clause in one of these contracts look like? Well, we find that it's usually reasonable for you to agree to be liable for your own intentionally destructive conduct and perhaps even conduct that's grossly negligent. Because that's not going to be the likely event that's going to occur. More than likely, if this worst case scenario happens, it's going to be an honest mistake that's based on a variety of very complicated technical factors that led to this significant downtime or data loss of the customer. And that's the type of event that you should want to reasonably address in your agreement with the customer. Perhaps your liability can be limited to the amount of the contract for the work that you're doing, or in the rare instance that you have some sort of insurance that covers it, You could try to limit your payment under the contract, your damages, to the insurance deductible in that rare case. So another important clause in the consulting contract is the intellectual property clause. And this clause somewhat ties into the confidentiality clause. But what it should define is who owns any of the IP that might result from the engagement. In our experience, obviously the customer is going to always own their pre-existing data and IP, of course. And you're going to own your pre-existing data and IP, of course. But what the contract should address is who owns any of the new IP that's developed during the course of the engagement. As one example, let's say you're engaged to test a customer network, and you discover a 0-day as a result of that engagement. Now, those can be really valuable, but who owns the IP for that? The vulnerability may be unique to your customer's system, but it might not be. In which case, who has the right to determine how, when, and whether to disclose to a vendor or use that 0-day in a different way? Are you, as the security professional, entitled to reuse that attack to discover vulnerabilities in engagements with future customers? Our clients typically want to be able to at least maintain that right. So at a minimum, we would recommend providing contractual rights to be able to do that. And lastly, before we risk boring you to death discussing legal contracts, we should briefly talk about the all-important termination clause, or breakup clause. What we're asking is what happens when you, or perhaps your customer, decide that, things really aren't working out that well with the engagement? Which party has a right to terminate the agreement, and in what situations? Does the customer get a full refund, a partial refund, delivery of an incomplete report? And how does the relationship wind down from there? Importantly, what do you do with that client data that you have thus far and that you've obtained until then? Are you obligated to destroy it all immediately upon termination of the agreement? Or do you have to give written notice to your customer that you've destroyed that information? These are all things that you would be wise to address in your customer contract. And they're all interrelated to your legal rights and obligations of the parties. They can be used as contractual tools to keep your customers' data and sensitive information secure, and they can protect your rights as a security consultant. So the big question is, how do you do all of these things and keep the contract to a reasonable, digestible length, right? But the answer is actually quite simple. You just use smaller font. So if that's the best takeaway you guys get today, I'll take it. Karen?
That's really good advice, Jake. I hope you guys were writing that down. So now we've addressed privilege and various contractual ways to protect the security consultant with a bent toward protecting or keeping the customer data secure. But other risks must be addressed as well, and we want to briefly mention just a few hot button issues. Specifically, I want to talk to you about data privacy laws and then device searches at the border. First, data privacy laws. Now, when you think about it, your goals as cybersecurity professionals seeking to safeguard your customers' data are actually pretty aligned with most data privacy regimes, which seek to protect personal data and other confidential information from unauthorized uses or disclosures. Global privacy laws can impact your work, so it's important that you recognize red flags when you come across them. Now, I want you to keep in mind that when I talk about privacy with my clients, I'm not only referring to the right to be free from surveillance. I'm also referring to an individual's control over their information, including the ability to object to uses that may not seem reasonably connected to the reason we all hand our data over to companies in the first place. And in the world of big data, the IoT, and artificial intelligence, it's really a challenge for us to exercise control over our personal information. And incidentally, it's a challenge for businesses in these ecosystems to untangle all the relationships and corresponding roles and responsibilities with respect to data. So we're in Vegas, and I'm willing to bet that you come across data that's linked to an individual, personally identifiable information, or PII, in the course of your work. And various laws control the way that PII can be collected, used, and shared. The core of these laws is notice and consent. Remember, control over one's information. That means that your customers must have collected consent in some way before letting you hack away and discover PII. And that means, for your own protection, you need to ensure that your customer agreements provide sufficient assurance that your customers are legally entitled, having done whatever is necessary under applicable privacy laws to allow you to access and perhaps even engage with their users' PII. For example, contractually requiring your customers to give notice of and obtain consent to allow third parties such as yourselves to perform network, systems, and other testing that could disclose personal data will reduce the risk that you could be named in a legal action for invasion of privacy or computer crime or other applicable laws. So the bottom line is data privacy laws may impact your work, and you should be aware of these impacts. Now, what about when data privacy laws and regulations mandate that you do something you don't want to do? This can occur when you or your customer might be required to notify authorities or individuals of a security incident involving unauthorized access to PII. For example, there are at least 48 states that have breach laws that require notification of security breaches involving PII. And these laws may define PII differently. They may vary in requiring who has to comply, what even constitutes a data breach, and the legal requirements for providing notice, the contents of those notices, and certain exemptions from notice and reporting obligations. Say, for example, you discover that a customer's databases containing PII were breached. Are you under a legal obligation to report this to authorities? Could your disclosure of a breach to your customer trigger reporting and notification obligations for them? But the practical takeaway here is pretty simple. As a security professional, you should be aware that when you discover a data breach, you or your customer might have mandatory notification obligations, and you want to be at least in a position to identify the triggers so you can seek specialized guidance to inform your compliance with the law. Likewise, the European General Data Privacy Regulation imposes new breach reporting obligations on your customers, or you, if you or they are subject to EU privacy law. But before you can even get to those obligations, your very access to PII held by your customers might in and of itself violate other uniquely stringent requirements of the GDPR. So in order to insulate yourself from that risk, you should contractually require your customers to not only comply generally with all applicable privacy laws, but to specifically comply with the GDPR. Most importantly, your customer agreements must demonstrate that you're acting at the instruction and direction of your customers, and that any PII that you access and use is for their purposes and not yours. This will shift most of the compliance burden and associated legal risk to your customers. Now, I understand that in some cases you may want to use certain of this data for your own business purposes, and there may be a way to accomplish this contractually. But you need to be aware of the risk that doing so could subject you to onerous EU privacy law requirements arising from the services that you provide and the nature of your relationship with your customers. It could also subject you to significant penalties for violations, and those penalties are pretty steep. They're up to 4% of gross annual revenues. Again, the takeaway is you should be aware of global privacy laws at a high level, particularly the GDPR, and you'll need to seek specialized guidance to inform your compliance and minimize the considerable risks. So, Jake, we've talked about the impact of privacy laws on customer engagements, but are there any other laws that
Sure. I think we have time to briefly address an area of law where I focus much of my practice on, and that's export control laws. And the issues that arise here are ultimately going to depend on what type of data and technology your customer has and how your customer is regulated by these laws, which then flows down to you. So the first question is your customer a defense contractor, or do they maintain ITAR data? If so, there are laws that require that only U.S. persons are permitted to access that ITAR data or technology. This means it could be a real problem if you use non-U.S. persons on an engagement that might permit access to a customer's ITAR data or technology. It could also pose a big problem if you were to export any of the customer's ITAR-controlled data or technology. Whether that would be by remotely exploiting your customer from abroad or by carrying a laptop that stores customer data or technology to your vacation spot in the Caribbean. This is an area of law you should at least be able to flag at a high level. And even if your customer is not ITAR controlled, do they have technology that's controlled by the EAR or Export Administration Regulations? This could include proprietary source code that utilizes encryption functionality, something that's seemingly very innocuous and ubiquitous to all software. It could also include sensitive technical documents that address control technology. And if so, if your customer deals in that type of data or technology, depending on a variety of factors, you or your customer may be required to obtain a license from the Department of Commerce prior to your accessing of that technology. And so here's an important note. These laws are generally strict liability regimes, which means that both you and your customer are responsible for complying, and you could both be liable for a violation. So perhaps this is another area you would be wise to address in your customer contract. And the upshot here is simple. You should know who your customer is, what they do, and how their technology and data is regulated. That way, you can put in place safeguards to remain legally compliant with accessing and exporting your customer's data and technology under U.S. export laws. So now, you may not have all followed the developments to the U.S. government's regulation of intrusion software and the related regulation of sharing vulnerability information, zero-day exploits, rootkits, things like that. Well, for those of you who haven't been following this issue quite as closely, let me just briefly summarize. 2 years ago, the Department of Commerce proposed fairly draconian export control rules that would have applied to exports of intrusion control software, which was a defined term, but it included penetration testing platforms, and it also related to the delivery of zero-day exploits and rootkits. Basically what the government did was they proposed to require an export license from the Department of Commerce prior to sharing any of these items outside of the United States, even if it was from a U.S. company to one of its subsidiaries or branch offices outside of the United States, or even if it was for defensive purposes. And on some level, the government's policy goal may have been somewhat noble because they were intending to prevent foreign governments from weaponizing certain technology. There were a whole host of problems with these proposed regulations. So the regulatory language was very ambiguous. It wasn't clear what type of software fit the bill of intrusion control software. It was unclear how the regulations related to open source software. And in most of industry's view, these would have been very bad regulations for industry. Well, the industry spoke up, joined together, and lobbied hard to defeat those proposed regulations. My law firm actually submitted comments to the proposed regulations. We presented arguments to the various government stakeholders in conjunction with offensive security, also on behalf of other companies here such as Core Security and Pony Express. And many of you others also submitted comments and joined in the opposition efforts. And those collective efforts really paid off. After much pushback, even some pushback at the political level, the government decided to withdraw the proposed regulations and go back to the drawing board where they're currently still at. They're renegotiating the proposed language and the proposed controls at the treaty level with other countries that are part of the Wassenaar arrangement. And to date, nothing new has really come out of this. The treaty negotiations are still ongoing. They were unable to arrive at any agreement last year. We understand that there were some meetings last month, and there will be more meetings in November. So perhaps we will find out more about this issue in December of this year. We're all sort of holding our collective breath. But as security experts and professionals, you all should have this issue on your radar for what comes next. And make sure that you follow this issue and other issues that are legal issues that are really important to you, that are regulatory issues, like backdoor encryption legislation. That way you have a chance to make sure that your voice is heard on any new form of proposed regulation.
Okay, so now we've covered privilege tools, contractual tools, and we've also looked at a few legal issues that might affect your customer engagements. But let's move on to the third and perhaps the most important, potentially the most effective tool, and that's technical mechanisms. And the reason why technical mechanisms might be the most important tool for you to use in safeguarding your customers' data is because these tools can potentially protect that data from disclosure to all of the groups that we identified at the beginning of this talk. Technical mechanisms are certainly useful against the public. They're perhaps the only protection against bad actors, and in some, but not all cases, they can be used as protection against government access to your customer data. More on that in just a moment. And importantly, though, this is where you come in, because due to your technical skills, you may be very effective. Now, this is rather basic, but to appreciate what technical tools can be leveraged, you should first identify all the places where you store or communicate sensitive customer data. This might include your internal corporate networks, private servers, cloud storage, whether public or private, email, and so on. And one technology that we're seeing increasing in popularity, and thus potentially also increasing exposure of sensitive information, is corporate chat apps like Slack or HipChat and Basecamp. So what we typically recommend to a client who is dealing with sensitive customer data is to identify what communications tools you're using that could be vulnerable, and then consider eliminating the obvious suspects.
So Karen, correct me if I'm wrong, but I don't think you're suggesting that nobody should use these tools. I think you're just saying that you should sit down and maybe look at this list and not use every single tool that you have for communicating your customer sensitive data.
That's a pretty good guess.
Okay. So we're not going to tell you like how strong you should make your encryption, what types of protocols to use, what your network security should look like, and all of that. There's plenty of other talks, I'm sure, this year on that. And that's not the scope of our talk. But what we do want to talk about are some of the legal issues that come up in the context of the physical movement of devices that include sensitive customer data. So many of the customers that we represent in this space are, spread throughout the world. As part of the globalization of this industry, many of our clients are frequently required to travel internationally, often with a laptop, a cell phone, or another mobile device that stores their customers' sensitive client data. Now, a natural question that arises is, what are your rights if the government agents wants to search your electronic devices at the airport? So if you've picked up a newspaper recently, you know that traveling internationally with a laptop can be complicated. But there's a lot more to be concerned with than just a carry-on laptop ban. What happens when a federal employee or officer asks to inspect your laptop, to open it up and boot it up, to take the laptop to another room and make a copy of your data? When can you say no? And when is your customer's data at risk? These are some of the questions we're going to try to address, and you might be somewhat surprised at a few of the answers. But before we address international travel and border search issues, which is where these issues are definitely most relevant, I want to first ask Karen about domestic travel. Karen, are any of these electronic device search issues and concerns relevant to purely domestic travel?
No, not really, because when you travel domestically, you're engaging with the TSA. And we all know that TSA's job is pretty straightforward. They want to make sure that you're not taking something dangerous onto an airplane. They want to be sure that your laptop isn't a bomb and that your cell phone is not a detonator. So in the ordinary course, their job is simply to screen us for safety. They screen you and whatever you're taking on the aircraft to make sure it doesn't pose a threat. However, when you present yourself at a US border, including in an airport, you will then be engaging with the Customs and Border Protection agents. Now, CBP is a component of the Department of Homeland Security and is responsible for securing the border, including at airports, and CBP's power to inspect people, their property, containers, and devices is really quite broad. And when you enter the United States, border agents will inspect you and your property, including your devices. Historically, constitutional protections are significantly reduced at the border and often give way to the government's interests in protecting national security and other interests as directed by Congress. And US courts have recognized that your constitutional rights are pretty limited when presenting yourself at the border to enter the United States. So let's take a look at why this is becoming more of a practical issue for cybersecurity professionals. This chart shows the number of electronic device searches at the border from 2015 to 2017. In 2015, CBP reported about 5,000 searches of electronic media. That number jumped to just under 25,000 in 2016, and recent numbers suggest electronic searches are headed upward. And if you notice the exponential relation, even those numbers appear to be very high and are certainly increasing. CBP is quick to point out that we have more than 1 million travelers entering the United States every day. This means that the chances of an electronic search affecting a given individual is close to 1 in 100,000. But that's still on pace to be 60,000 electronic searches each year. And to those 60,000 individuals, this is a very real issue. So you should be prepared for the possibility that the government may want to search your laptop or other devices, and when you present yourself at the border. Now, as you probably know, the Fourth Amendment requires the government to get a warrant before searching your possessions, subject to various exceptions. One of those exceptions is the border search exception, which gives the government broad authority to conduct searches at the border without a warrant, and it applies to all items as I indicated. You may have heard about a really important Supreme Court case decided in 2014 called Riley versus California. In that case, this court held that searching the digital contents of a cell phone is different than traditional searches in the context of conducting an arrest due to the highly intimate nature of cell phones. And officers now need a warrant to conduct that kind of search. This is a very important case, but for now, at the border, federal officers may search the digital contents of your device with no warrant. Nonetheless, lawyers who have challenged device searches at the border often cite Riley, and we expect the momentum will build to extend Riley's warrant requirement to electronic searches at the border. Now, there are two main categories of CBP searches: cursory searches and forensic searches. Random cursory searches can be conducted with no suspicion and obviously no warrant. And these searches involve asking you to open your laptop or your phone, turn it on. The agents want to take a look at your device just to confirm that it doesn't contain contraband or evidence of a crime. But a forensic search is much more invasive. It can include an inspection of the contents of your device, data stored locally on it, or making a full copy of the data for examination later. Now, courts disagree about what's reasonable under the Fourth Amendment in this context, and the Supreme Court hasn't resolved the issue. In the majority of jurisdictions, federal officers can perform these comprehensive forensic searches with no suspicion and no warrant. Although states within the Ninth Circuit, home to Las Vegas and California, offer a bit more protection. Those courts have held that the government needs reasonable suspicion before conducting these searches. What does that mean? it means the federal officer need only a low but particularized suspicion that there may be evidence of criminal activity on your device.
So what can you do? Can you lawfully enter a kill code to wipe your hard drive? The answer is no. That would probably be destroying evidence, or at least the government could allege that that's destroying evidence, which is a federal crime. So can you lawfully tell the officer that you don't know or remember your password? Maybe, but probably not, because that could be making a false statement, assuming that you do know your password and can access the data, which is another federal crime. And this is perhaps the most difficult question. Can border agents demand your password, force you to give them your password to unlock your phone or your laptop? Karen, what do you think?
So at a border crossing, the CBP may demand your password to unlock your cell phone. But you don't have to give it to them, although the strategy doesn't always end well. Now, that said, CBP can't take you for a helicopter ride across the desert. And if you're a US person, they have to eventually let you cross the border. It's just that your device can't come with you. Although lawful US persons are not denied entry without a hearing, non-US persons trying to enter the country on a visa could be denied entry for refusing to provide their password. And as I alluded to earlier, CBP has broad authority to physically remove and inspect your device, and they may be more likely to do it if their suspicion is raised to the legal standard by your refusal to provide your password or cooperate. And once they remove your device, they can make a copy of the data for later inspection. They can keep it for 5 days with an option to extend for 15 additional days with prior approval to perform more extensive searches. And border agents can also question you, which can be really intimidating. So understandably, many people decide to just comply with the demand. Now, if you have information protected by the attorney-client privilege, you may be able to invoke the privilege by telling the border agent that you've got privileged information on your device and you can't disclose it. That might not get you very far, but it might be somewhat helpful because it triggers additional handling procedures. CBP's policy is that if someone asserts a legal privilege, the border agent contacts the CBP chief counsel. The chief counsel notes the assertion of privilege, but they'll still keep the device for copying. Importantly, you can later assert this privilege at trial to try to exclude improperly obtained evidence, and it'll be very useful to demonstrate that you asserted the privilege right at the outset instead of sitting on that right. So here's the takeaway. Your constitutional protections are checked at the border, your privacy is limited. At least for now, you can't look to the law for a complete answer. You don't have to give your password to CBP or allow them to search the contents of your device. But if you go this route, they may take your device, and this is why technical tools can be so very effective. You should limit the sensitive customer data that you store on electronic devices, and you should encrypt all device data. So if your encounter with CBP escalates, your hard drive, and they take your hard drive, your data will be inaccessible. You should also disable all automatic logins to cloud storage and email, delete cache storage of passwords, data, and so forth. So if you decide to provide your password, the information the government can access or collect is limited. And one helpful limiting factor is that under current DHS policy, border agents can only search your device and the data stored locally on it. They can ask you for your password to unlock the device, but they can't ask you for the password to your iCloud account, your Gmail account, or your social media account. And another really important point is that the more you make the government work harder to access the data on your device, like sending it to the FBI to try to break the encryption, the better the legal arguments you may have in the future about whether their steps were unreasonable under the Fourth Amendment. So Jake, let me ask you, what else can our clients do? What are some of the technical tools we've been alluding to? What do they look like?
Sure, and we're almost out of time here, so I won't have time to get into all the technical tools in detailed discussion, but that's okay, because we understand that the folks from Cali are going to be doing a demo of one of these tools tomorrow at the Cali Dojo. And so, actually, we're out of time, but the two tools, technical tools that I know of, are the 1Password travel mode tool and the Kali Linux full disk encryption Luke's Nuke feature. So, with that, thank you all for attending the talk, Thanks to Black Hat for the opportunity. Thanks for the team at OffSec for the support.